Your Honour, my name is Robby Johnstone, and I appear for the defendant, Marshall Ike. Your Honour, the defence submits to the court that the Crown's evidence be ruled as inadmissible in pursuant to Section 590AA of the Criminal Code. I will provide three arguments that will highlight that the Crown's evidence was obtained through the reckless non-compliance with the procedures and standards by the arresting police officers, thus concluding that as a matter of public policy and fairness, the evidence should be ruled as inadmissible. Your Honour, my client was questioned twice prior to the formal recorded interview. In the second instance of questioning, my client made admissions to which 84 charges of breaking and entering were based upon. These admissions were not recorded, neither electronically or in written form. Now, Your Honour, in the circumstances, it was entirely practical for the officer questioning my client to record these admissions as he was not driving the vehicle. Now, this is a direct contravention of sections 436 subsection 1 and section 437 subsection 3 of the Police Powers and Responsibilities Act. Your Honour, this is the basis of my first argument, as there is simply no evidence of my client's admissions to these subsequent robberies other than the police officers merely recalling what was said in the vehicle at the recorded interview without any correction or justification from my client. Your Honour, my second argument concerns the conduct of the officers prior to and during the questioning. The officers at no point informed my client of his right to contact a parent, guardian, relative, or lawyer as per section 418 of the Police Powers and Responsibilities Act. Furthermore, the police officers did not sufficiently caution my client as to his right to silence in the manner outlined within section 26 of Schedule 9 of the Police Powers and Responsibilities Regulation, which is a direct contravention of section 431 of the Police Powers and Responsibilities Act. Your Honour, there is simply no discernible reason as to why the trained and experienced arresting officers could not comply with their duties at the time. Additionally, it is not too fanciful to conclude that the failure by the police officers to inform my client of his rights furthered my client's already vulnerable position as a 14-year-old child. To further illustrate my client's vulnerability at the time, I would like to direct the court to section 25 of Schedule 9 of the Police Powers and Responsibilities Regulation. This section outlines the manner in which police must question Aboriginal and Torres Strait Islander people. The police officers must first ask questions necessary to establish the person's level of education and understanding. Now, this is done in order to ensure that the person understands what's being asked of them and that they are able to effectively communicate answers to the police officers' questions. Now, although this section refers to adults, this only necessitates the importance of the standard of the diligence that the police officers must demonstrate when questioning Indigenous children, as they are comparatively disadvantaged to their adult counterparts. However, in this case, the arresting officers instead exploited my client's vulnerable position. This is highlighted in the second instance of questioning, where the officers were pointing out and then asking my client if he had broken into 84 subsequent properties, to which my client responded in the affirmative to every single one. Your Honour, I submit to the court that the affirmative answers are due to gratuitous concurrence. Now, this occurs where a person, usually of Indigenous background, responds in the affirmative to propositions and questions put forward to them, whether they truly agree with them or not. This is a significant and well-documented cultural issue, and it is reasonable to deduce that, given that the arrest occurred in a predominantly Indigenous location, that the officers should have received training or should be aware of the issue. Thereby, given the vulnerability of my client at the time, the defense submits to the court that he answered in the affirmative as he thought that it was what the officers wanted, not because he actually committed those subsequent offences. Your Honour, I now refer you to section 421, subsection 2 of the Police Powers and Responsibilities Act, wherein, before questioning a child, a police officer must, if practical, allow the child to speak to a support person chosen by the child. Furthermore, the support person must be present while the child is being questioned. Although the arresting officers complied in part with this requirement by allowing the support person to be present during the recorded interview, the officers still questioned my client without a support person present, and they did not allow my client to choose his own support person. Your Honour, there is simply no reason as to why it was not practical to allow my client to speak to a support person of his choosing. If my client had chosen his support person in accordance with the legislature, he may have felt more comfortable and may not have incriminated himself due to gratuitous concurrence in the recorded interview. My client's vulnerability was ultimately exploited here, Your Honour, and thus the officers received recorded admissions that forms the basis of my learned friend's case. Your Honour, I put forward to the court that the police officers' conduct strongly infers that they ultimately wanted to obtain a guilty admission and conviction at the behest of the procedures that they are obliged to follow. This leads me to my concluding argument. Your Honour, although there is pressure from the public to prosecute and convict guilty offenders, there is also the need to ensure that this conviction is obtained fairly and in accordance with the relative legislature and common law principles. The basis of this argument, Your Honour, derives from the principles found in Bunning and Cross as well as the Crown and Ireland. In the case of Bunning and Cross, Justice Stephen and Aiken stated that the court should not be seen to be acquiescent in the fact of the unlawful conduct of those whose task it is to enforce the law, further stating that mere accidental non-compliance with statutory safeguards that do not overtly defy the will of the legislature would not lead to the inadmissibility of evidence. Your Honour, under Section 5 of the Police Powers and Responsibilities Act, one of the purposes of the Act is to ensure fairness to and to protect the rights of persons against whom police officers exercise powers under the Act. The non-compliance of the arresting officers was not merely accidental. They recklessly contravened their statutory duties in order to ensure a guilty admission from my client, and thus my client's rights were not adequately protected as intended by the legislature. Thereby, Your Honour, the defence humbly submits that the court exercises their judicial discretion under Section 590AA of the Criminal Code and reject the Crown's evidence on the basis that to admit this evidence would undermine the principles of fairness and justice. Thank you.